Gentlelady is recognized for 5 minutes.
Thank you, Mr. Speaker. And again, I thank my colleague from Georgia for the great leadership he shows in the Rules Committee and on the floor. Mr. Speaker, our colleagues on the other side of the aisle have made many comments. Some of them I'm going to do my best to refute comment by comment. Others I'm just going to talk about in general. But one charge is that Congress should stay out of the business of governing D.C. Article 1, Section 8 of the U.S. Constitution gives Congress explicit jurisdiction over the country's seat of government. The extent to which Congress should oversee or intervene in the governance of the district is a debate for another day, but it's clearly our responsibility. Current law compels congressional oversight, and we must exercise responsibly that jurisdiction. That includes acting to stop legislation that clearly violates the constitutional freedoms of the citizens of the district. Mr. Speaker, it's important to note that women are protected by law, both federal and D.C., from discrimination on the basis of pregnancy. Their personal medical decisions are also private under HIPAA protections. This discussion is not about how someone chooses to conduct their personal affairs. It's about whether the D.C. government may force an organization to hire, retain, and promote someone who actively opposes their central mission and core beliefs. Pro-life groups, religious organizations, and Republicans are not the only ones to see significant problems with RHNDA. Even former D.C. Mayor Vincent Gray cautioned that RHNDA goes too far and called the bill, quote, legally insufficient, end quote, and, quote, legally problematic. Whatever his position may be on life issues, he recognized that the approach taken by the City Council does not adequately protect free exercise. He further noted that the measure, quote, raises serious concerns under the Constitution and under the Religious Freedom Restoration Act, end quote. The district's own Attorney General also expressed concerns that, quote, religious organizations, religiously affiliated organizations, religiously driven for-profit entities, and political organizations may have strong First Amendment and RFRA grounds for challenging the law's applicability to them. The D.C. Council's cavalier attitude toward the constitutional rights protecting religious practice and belief is deeply troubling. Unfortunately, RHNDA is a harbinger of continued efforts to undermine the right of free exercise and association. RHNDA denies these fundamental rights to pro-life organizations and religious groups who do not fit the narrow definition of ministers exempted from the D.C. law. Under this law, these organizations can be forced to hire, retain, and promote individuals who work actively against their central mission and core beliefs. The clear and shameless targeting of these organizations must be opposed by anyone who values the rights guaranteed to us by the First Amendment. Mr. Speaker, our oath of office requires us to preserve, protect, and defend the Constitution of the United States. The Supreme Court ruled unanimously in 2012 that religious organizations have the right to hire individuals that support their mission, saying, quote, the interests of society and the enforcement of employment discrimination statutes is undoubtedly important, but so too is the interest of religious groups in choosing who will preach their beliefs, teach their faith, and carry out their mission. The church must be free to choose those who will guide it on its way, end quote. Consistent with our oath of office, I commend this rule and disapproval resolution for our support. I yield back.